Have you ever heard the claim, if your spouse is US citizen, you can legally obtain a green card? It sounds straightforward, right? Like dream come true. But before you celebrate or panic, it's critical to know, yes, marriage to a US citizen can make you eligible, but under the Trump administration's latest immigration policies, that part is not as smooth as it used to be, and in some cases it's downright dangerous. In this video, I'll break down how marriage-based green cards work in principle, what new rules Trump introduced in 2025, especially mandatory interviews, financial scrutiny, and deportation risk. And the third one is what you can do if you find yourself in that situation. By the end, you know the real deal. No clickbait, no hype, just facts, okay? First of the kernel of truth. Under US immigration law, a lawful permanent resident, that is the green card holder, or a US citizen can sponsor their spouse for a green card. That has been a long established legal pathway to permanent residency, rooted in the principle of family unity and codified in the Immigration and Nationality Act. But, and here is the critical but, saying you can get a green card if married to a US citizen is not the same as saying the process has been eased or guaranteed. In fact, under President Trump's 2025 immigration policies, that pathway became much more restrictive. New application forms and public charge scrutiny on January 2018-25, the Trump administration mandated updated versions of key immigration forms, such as Form I-485, application to register permanent residence or adjust status. The new version reintroduces the term alien and beef up the public charge section, requiring comprehensive disclosure of household income, assets, debts, and any US public assistance received. It even asks about education, professional licenses, and skills, areas not previously required. Then the second is mandatory in-person interview and red flag vetting. Whereas under the Biden era, many marriage-based green card applicants without red flags skipped in-person interview. The Trump era policies reintroduced mandatory interviews for virtually all marriage-based applicants. These require couples to prove their relationship's authenticity through photographs, joint bank accounts, leases, affidavits, and more. Then the third is processing delays, evidence requests, and extra scrutiny. USCIS timeline for marriage-based cases expanded dramatically. Biometrics, interviews, and approvals now often take months longer. The agency has ramped up requests for evidence, RFEs, field visits, and even calls to family members to verify details. One lawyer shared that officers can text the US citizen spouse requesting private documentation like criminal records. And the fourth one is deportation risk. Family-based petition does not halt removal. Perhaps most alarmingly, as of 1st of August 2025, USCIS announced that submitting a Form I-130 or I-485, even still pending, does not grant legal status or immunity from deportation. Staff may issue a notice to appear NTA at any stage if they deem the applicant removable, even if married to a US citizen. This policy covers both new and pending cases and applies to people who entered without inspection, overstayed, or lost TPS. Then the fifth one is intensified fraud mitigation and system overhaul. USCIS is now maintaining the family-based petitions do not guarantee legal status, warning that fraud prevention is their priority. Approval of a petition doesn't shield someone from removal proceedings if they are found ineligible or fraudulent. That's seismic shift from the traditional assumptions that marriage to a citizen ensures at least temporary protection. So what does this mean if you are married or planning to marry a US citizen and want to pursue a green card? Marriage is still a legal basis for a green card. Don't let anyone tell you otherwise. Prepare for serious scrutiny. Use the correct updated form I-130, I-485. Double check edition dates. Collect strong documentations, joint accounts, photos, leases, affidavits, communication logs, travel itineraries, anything that proves your life is genuinely shared. Expect delays and RFEs. Plan timelines accordingly. Don't leave gaps. Respond to evidence requests thoroughly and on time. Understand there is no automatic protection from deportation. Even if you have filed, an NTA may be issued. Stay informed of your rights. Stay in touch with your attorney and follow legal advice closely. Consult with an immigration attorney if your case is complex, especially if you are undocumented, overstayed, or have prior removals. Getting expert help matters more now than ever. Marriage to a US citizen can still be your path to a green card, but under Trump's era policies in 2025, it is tougher, slower, and riskier. If you are navigating that path, the key is preparation, honesty, and legal guidance. Thanks for watching. Hit the subscribe button for more up-to-the-minute immigration breakdowns. And tell us in the comments, what challenges have you faced in the green card process? Let's cover them next time. Okay, bye. I'll see you in the next one.